Thank you, everyone, for joining us for our 2024 Privacy and Cybersecurity Year in Review. My name is Alex Cameron, and with my colleague Kateri-Anne Grenier, I co-lead the Privacy and Cybersecurity group here at Fasken. We are thrilled today to bring together 12 partners and associates on our national team, which is about a third of our team, to cover a range of key developments from 2024 and things to watch for in 2025. Now, before we begin, I have a quick housekeeping announcement. I'd like to draw your attention to the survey, which will be available at the conclusion of the session. We really do value your feedback on these sessions and encourage you to fill in the survey before you leave today. There are some other housekeeping items up on the slide there. If you do have questions as we're going, please do submit those in the Q&A box. We have tried to take into consideration in preparing for today questions that were submitted in advance, and so we'll try to touch on those. But if you do have questions as we're going, please submit them. We'll try to either address them along the way or save some time at the end for questions. Now, today's session does qualify for a variety of professional education credits, and you will find at the end of the session there'll be QR codes and links to obtain certificates for your attendance. And if you don't have a chance to fill in those forms today, then you will receive a certificate next week. Now, Kateri and I firstly will kick things off with a few highlights of key trends and things to watch for at a high level. And so, Kateri, over to you first.
Thank you for this introduction, Alex. This is going to be a great session. So among the key trends from the past year, I think we can say that a lot of our clients, either Quebec-based or across Canada, are still very much focused on compliance with Quebec's Law 25, still putting in a lot of efforts to reach compliance and asking us various questions and opinions. Also, we've started giving a lot of legal advice on all issues related to artificial intelligence. This is, of course, a multidisciplinary focus area. But as a team, in the privacy team, we have been getting a lot of questions regarding the collection and use of personal information in AI projects. Of course, the cyber breaches continue, including a range of ransomware by different criminal groups. We've been called to help clients on several breaches this year. And this year is also, we can report that one of the largest payment actually ever made, $75 million, was paid to an attacker. So that was a significant development.
Agreed, and certainly on the cyber front and artificial intelligence as well, among other trends. Continued board of directors focus on these key risk areas and opportunity areas. So a lot of time spent with boards and with management teams, working with boards on cyber risk and artificial intelligence. Seeing artificial intelligence in the context of cyber attacks being perpetrated against clients as well. So no great surprise that attackers are using those tools to perpetrate attacks more effectively. Service provider breaches definitely on the rise. A lot of incidents involving service providers these days. And a couple of others just on the cyber front, a lot of good law enforcement wins. So we've had great successes working with law enforcement to achieve disruption of attacks and in some cases arrests and securing assets of attacker groups. And then finally, in the cyber area, I think one of the other things has arisen is less appetite for companies to bear the loss of a cyber incident where it is caused by a service provider, for example. So historically, those quite often were losses that just were accepted by companies or by their insurers. But increasingly, we are seeing a much stronger appetite to seek compensation from providers where they're the cause of your losses, and to pursue those types of claims where available. On the class action front, lots of developments continuing in Canada in this area as well. Just very briefly, still many cases where you have third parties hacking into companies where the companies end up being sued, typically in a privacy class action, with plaintiffs continuing to advance new theories in those cases. A number of the plaintiff firms focusing on the 4 provinces in Canada that have statutory torts for invasion of privacy under the Privacy Acts. And the further trend I would highlight is that we've seen increased plaintiff interest in what I would call ordinary business practice type cases. So these are cases where there hasn't been a third party hack, but the allegation is more in the nature of the company having collected, used, or disclosed information without adequately obtaining consent, allegedly, or making the proper disclosures, and that therefore these are characterized as intentional invasions of privacy for the purpose of common law and statutory privacy tort claims. And so plaintiffs shifting their focus a little bit to those types of cases where they can, in theory, obtain large sums of money without having to prove harm. So certainly we've seen an increase in that activity. Kateri?
Sure. So maybe a couple of cases to mention for privacy class actions in Quebec. First, there was a settlement authorized in the Levy versus Nissan case, which I believe was also active in Ontario. So it's a settlement involving both the Quebec and Ontario groups. The settlement was authorized in Quebec in June of 2024, will affect close to 400,000 people. And the total amount of the settlement is close to $3 million in terms of potential settlement payments to be made by Nissan, including counsel fees. One of the questions at stake in this class action was whether Nissan, who had suffered an unauthorized breach by a third party, had taken too much time, too long before notifying the affected individuals. So unfortunately, we will never know what the court ultimately thought of Nissan's conduct and behavior in handling the breach. There was also a class action authorized against Google for the product Google Photos on April 15, 2024. So that's one to watch in the future. And there's an attempt to have a class action certified in 2024 in the case Doan versus Clearview AI. Clearview AI was, if you remember, the subject of a federal privacy commissioner's investigation for its scraping of images of individuals on the internet. So while the company claims to no longer be offering these services and no longer having this practice, there will be an hearing further down the road on the certification. And last is the Home Depot case. You will also remember that Home Depot was subject to federal privacy commissioner's investigation on some collecting and use of personal information when collecting email addresses from consumers who wanted electronic receipts for purchases in store. So the class action was partially authorized, which means that only the claim on punitive damages was allowed to continue, while the claim for compensatory damages was deemed too hypothetical. The plaintiffs were asking to be compensated based on the value of the information that Home Depot collected and then sent to Facebook. So that's an interesting outcome, and certainly more to come. Let's watch this case closely as well.
And on the legislative front, three main areas. We have privacy, cybersecurity, and artificial intelligence legislation from 2024. Privacy side, we have, of course, Bill C-27, which would amend PIPEDA, bring in the Artificial Intelligence and Data Act. And that currently is in the House of Commons committee. There haven't been any meetings since September 2024. Questionable whether this is, a strong priority given current political situation. So we'll see where that one leads. Kateri, any things from Law 25 to comment on?
Sure. So maybe two things on Law 25. Since the adoption and even coming into force, Commission d'accès à l'information has not been issuing any sanctions or penalties. We believe that the very it was in a collaboration phase for the last years, but this will slowly change, and we are getting messages from the Commission d'accès that they have recently appointed a new president and will start to take actions against companies and public bodies who do not comply with Law 25. So it has started slowly, but we should expect a change of pace. Also, for all entities who are subject to the authority of the AMF, so Autorité des marchés financiers, most likely in the financial sector, there are new rules that were adopted and that will come into force on April 23rd, 2005, regarding incident response and incident notification. So the AMF rules provide that organizations who are subject to the AMF authority will require to have incident response policy, will be required to designate somebody responsible for the incident response. They will have to report potentially adverse incidents. And it is worth noting that the timeline for doing that will be 24 hours. So quite a different system than the one we are used to under privacy and access and privacy laws. And the reporting will have to continue every 3 days until the incident is resolved. Also, there will be record keeping obligations up to 5 years under these new rules. So definitely something to get acquainted with and to know if you are a body regulated by this authority. And last but not least, as Alex was saying, in 2024, we saw a tremendous industry and regulatory focus on AI, taking all shapes and course, and Canada positioning itself with new legislation, but also sort of waiting to see what other countries and states are doing to address this really important issue. So this will bring us to our first presentation of the day by Julie Uzan-Naulin and Sam Delechantos, which will talk about international AI comparisons. So have a good seminar, everybody, and the mic is yours, Julie and Sam.
Thank you, everybody, for being here. I'm Julie Uzan-Naulin, lawyer, a partner at the Montreal office of Fasken law firm in the privacy group, with my colleague Samantha Delechantos, who are going to give you an overview of the AI development in the world, actually, in the other country. Thank you.
Yes, and so I'll start us off by talking about what AI laws exist globally. Since there's been a lot of discussion over the last year or two, a lot of organizations may be considering what actually is the status globally right now, and what do they have to think about, especially as Canada moves forward, thinking about AI and its proposed legislation that's still on the table. And so currently, right now, we have a couple of AI acts that have been passed, and then a number of guidances. The most prominent is the EU AI Act, which Julie will speak about in more detail shortly. That was passed earlier this year and is currently in force. There is also in the US, the Colorado AI Act that was passed earlier this year, which I will speak about in a moment. There is also the China AI management provisions, which are currently in force within China. And then several countries have actually introduced draft legislation, and those include Japan, Chile, Brazil, some other US states, as well as Canada. And most of those are still pending as we speak and are yet to be passed. And then other countries have also implemented guidelines, directives, and frameworks at the moment with the intention to likely issue legislation further down the line in the next couple of years. And so firstly, I'll turn to the US. So as I mentioned, Colorado is the only state currently that has passed an AI legislation, and that is called the Consumer Protections for Artificial Intelligence Act. Now, that will be effective on February 1st, 2026. So organizations do have some time before they have to come into full compliance with the Act. The Act does focus on high-risk AI systems, which is very similar to a number of different acts globally, and it requires specific notices to be given to consumers regarding the use of AI. It requires organizations to audit for algorithmic bias. It also requires that a risk management program is maintained by organizations and reviewed regularly. And part of that is conducting impact assessments on any AI systems used or deployed. At the federal level, we have the executive order on the safe, secure, and trustworthy development and use of artificial intelligence. This really just sets the stage that the US is considering AI as a very strategic tool for growth and innovation in the future, but it also recognizes the risk that this type of technology poses. And so it's currently enforced, and it imposes primarily obligations on government entities in the US. Lastly, some sort of smaller sector-specific acts that have come into force. In specifically New York and Illinois have actually adopted requirements around the use of AI in the employment and recruitment sectors. And basically, they're focusing on ensuring that organizations are using AI in a safe manner when looking at making recruiting decisions. And so New York is currently in force, and Illinois will be effective as of January 1st, 2026. And so some key considerations for Canadian companies is that any companies operating in Colorado in the US and that develop or deploy AI must really think about complying with these laws. It would be prudent to consider the risk that any AI product or use of AI products poses and whether it is high risk. And if it is considered high risk or may be considered high risk, thinking about risk mitigation measures and conducting audits early to ensure that when these laws do come into force, your corporation is in compliance. And so next I'll hand over to Julie to speak about the EU.
Thank you, Sam. One of the most famous acts is actually the EU AI Act, which was adopted in June 2024 and entered into force in August 2024. This being said, a lot of provision will be implemented gradually from February 2025, for example, for the first prohibition of certain AI system, to August 2027 for high-risk AI system. Note that the provision on penalties would be applicable as of June 2025. How the EU AI Act has been created? Actually, it has been created in order to take into account the risk linked to the AI system. So it has adopted a risk-based approach. The Act distinguished between unacceptable risk, high risk, limited risk, and minimal risk. Unacceptable risks are prohibited. So any kind of AI system, such as real-time facial recognition system, will be prohibited as of February 2025. Other AI systems, such as autonomous vehicle, medical device, would be considered as a high risk, which would not be prohibited, but subject to additional obligation, training obligation, transparency requirement, etc. Limited risk AI system pose certain transparency requirement and can be implemented. We can think about chatbot systems, which is a limited risk AI system. Finally, the lower risk provided by the EU AI Act is the minimal risk, which is actually system not belonging to the three first categories. So the EU AI Act imposes a wide range of obligations on various actors in the life cycle. But the obligation will depend on whether the company acts as the creator of the system, which is the provider under the Act, or the user of the system, which would be considered as the deployer of the system. And in addition to the AI Act, company using or creating AI system should also comply with, for example, the GDPR in case where personal information is involved in the context of AI system. Why does this act important for Canadian companies? Well, actually, this act is really important for Canadian companies because of its territorial scope. Indeed, it imposes obligation on any kind of companies which place on the EU market an AI system, whatever this company is located in the EU market. A Canadian company may also have an establishment in the EU. So in that case, the AI regulation will also apply to this establishment in the EU. Finally, if the output is produced by the AI system and would be used in the EU, thus the AI Act would be applicable for the Canadian company. But what is important to remind here is that in Quebec, we have not yet a specific regulation regarding AI, but we have some guidance, some provision which can be useful in the Quebec Private Sector Act. For example, we have some provision regarding the need to carry out a privacy impact assessment in the context of an IT tool impacted personal information. We have some provision regarding profiling. We have some provision too regarding automated decision making. Finally, even we have no specific law in the context of AI in Quebec, we have a statement from the Montreal City regarding the responsible development of AI system. So we'll see in the future if we will have more development in Quebec regarding AI. Note that, as Samantha will explain to you, some development exists at the federal level.
Yes, and just to finalize this, as Alex mentioned and Kateri mentioned already, Bill C-27 is still pending with the ADA, which is the Artificial Intelligence Data Act. Right now, as far as we know, it's been paused until February 2025. So we expect further discussion on that early in the new year. Obviously, adoption and implementation is unknown at the moment. And so with that, I will pass it over to the next session, my colleague Heather.
Hi, everyone. I'm going to share with you some recent updates from the Federal Privacy Commissioner about the use of deceptive design patterns in digital interfaces. And so this update is relevant for organizations that are looking to adopt privacy-first design practices for their websites and their mobile apps, and make sure that the design of those platforms is consistent with your obligations under Canadian privacy laws, particularly requirements that relate to individual consent and openness and transparency. So earlier this year, the Federal Privacy Commissioner coordinated and participated in a global sweep of over 1,000 websites and mobile apps. And this was in collaboration with a global network of other privacy enforcement authorities. And in the Canadian context, the sweep looked at about 145 different publicly accessible websites and apps across many different sectors. So retail, news and entertainment, social media, dating, travel and accommodation, and also banking and financial services. And the sweepers, as they're called, basically replicated the consumer experience. And so they went onto these websites and these apps and they tried to figure out how they could make privacy choices, how they could obtain information about the organization's privacy practices, and how they could delete an account. The OPC has since published a report of its findings, and this report concluded that the vast majority of websites and apps that were reviewed contained at least one indicator of a deceptive design pattern. So that's a design pattern that's used to influence or manipulate or coerce a user into making a decision that is not necessarily in their best interests. And in the privacy context, that usually means users are prevented from making informed decisions about the collection, use, or disclosure of their personal information. The Commissioner's report highlighted 5 types of deceptive design patterns, which I will describe to you so that you can go off and make sure that they don't currently exist on your business's digital platforms. The most common deceptive design pattern that the privacy sweep identified is the use of complex and confusing language. This will be unsurprising to many, but privacy policies are often too long, too difficult to read, and very difficult to navigate. And so my tip to you is to try and keep your privacy policy below 3,000 words. That was the number flagged by in the report. And also ensure that it's written at a reading level that's appropriate for someone with an 8th grade education. The second type of deceptive design pattern that the report looked at is called interface interference. And this involves design patterns that are distracting or conflicting and disrupt or confuse the user. And so one example of this is false hierarchies, where certain visual elements are emphasized to direct users towards a less privacy protective choice. So you might have seen a cookie banner, for example, where the option to accept all cookies, accept all tracking cookies is big and bright in comparison to the less privacy protective option to decline optional cookies, which might be grayed out or quite small in comparison. Another deceptive design pattern is nagging, and this involves repeated prompts or actions to try and steer the user towards a particular less privacy respectful choice. I'm sure we've all experienced this one, but the example where there's a repeated prompt or a repeated pop-up, even after you've said, no, thank you, or maybe not now. And that repeated prompt is encouraging you to download an app instead of remaining on the website version, where the app would enable the collection of more personal information than if you just remained on the website. The fourth deceptive design pattern that the privacy sweep looked at was obstruction. And this, just like it sounds, involves design patterns that create obstacles for users who want to protect their privacy. So click fatigue is a very common example of this, where users are forced to navigate through a maze of different steps in order to find privacy settings or delete their account. Notably, the OPC's sweep found that only about a quarter of websites and apps that they looked at allowed a user to delete their account with just 2 clicks or fewer. So my advice to you is to make sure that privacy settings are easy to find, ideally in just a few clicks. Finally, the last deceptive design pattern that this sweep focused on is forced action. And this is where a user is required to complete a specific action, often involving the provision of personal information in order to achieve an objective. And so in the example you'll see here, an individual who wants to create an account has to provide their first name and their email. That seems reasonable for the purposes of account creation. But when they want to delete their account, they have to provide more personal information than was initially required when they created the account. So things like their last name and their place of residence, which is the forced over collection of personal information in order to achieve the objective of deleting one's account. So these are 5 deceptive design patterns that I would encourage organizations to steer clear of in order to make sure that you're meeting your obligations under applicable privacy laws. So, for example, avoiding the use of false hierarchies makes it more likely that you are obtaining meaningful consent from users. I will say that the findings of the SWEEP report and the related guidance that has come out of this from the federal commissioner is not binding on organizations, but it does provide really good examples of what the federal commissioner would likely find acceptable or unacceptable if an organization's privacy practices were ever scrutinized as part of a privacy complaint or an investigation. And more generally, I think that this is a very good reminder that the federal and provincial privacy commissioners continue to be very focused on protecting individual privacy in the digital world. So with that, I will pass things along to my colleague, Nareg.
Thanks, Heather. Hi, folks. My name is Nareg Froundjian. I'm an associate in the Montreal office. I spend my time mostly helping clients prepare for and navigate cybersecurity breaches. So today, what we're going to do is walk you through some updates from commissioners. I'm going to cover 4 jurisdictions and 4 updates for 2024. But before we jump into breach reporting, let's talk about a quick refresher on what a breach is. And again, broad strokes here, but a breach is generally access, use, disclosure unauthorized by law of personal information, or the loss of personal information, or another breach of security of personal information. You might recognize the Quebec flag next to certain categories. That's because that's a Quebec exclusive, at least in the private sector. The 4 jurisdictions have enacted privacy breach reporting at different times. Alberta did so in 2010, Canada in 2018. In 2022, Quebec followed, and Ontario has a breach reporting obligation for health sector since 2016. So with that, let's move to Alberta. So in Alberta, after 14 years, for 14 years, Alberta used to publish breach notification decisions. This is kind of what it looks like. This is their website. And anytime an organization reported a breach, they would publish a decision explaining their analysis of why there was a real risk of significant harm and why the organization needed to notify. Practically, most organizations had already notified at that point. The privacy commissioner would review their notices, say, all good, no need to reissue a notice. And that went on for about 14 years until April 2024, where in a marked departure from its current practice, the Alberta Privacy Commissioner decided that it was no longer publishing as a rule only for failures to report or notify. So if organizations did everything right, their name would not show up. And in our experience, many organizations were at times reluctant to notify or to preemptively notify the commissioner for fear of their name showing up publicly on the breach on the commissioner's website. So that chilling effect has disappeared. Instead, the privacy commissioner is issuing a private closing letter, which in turn encourages reporting in our view. That being said, the key takeaway here is that there should be, at least for organizations, less hesitancy to report in Alberta, especially if you did everything right, because it won't become public. As a practitioner, it might be a little bit bittersweet because we had 14 years of decisions on how a commissioner thought of the interpretation of real risk of significant harm, and we don't have as rich of a body of knowledge in other provinces or jurisdictions. Now, will other provinces follow on that incentives to notify? And by other provinces, I mean, of course, Quebec. So in Quebec, since 2022, there has been a mandatory breach reporting regime, and the privacy commissioner has taken different approaches at times since the enactment of that law. In early 2022, they were responding to access to information requests from media and giving the names of organizations that had reported a breach. They quickly stopped that and said they're no longer going to be doing that. Media somewhat revolted, and the commissioner decided to change its mind and decide, well, it's not only media that gets access to it, everybody gets access to it, and started publishing the names and the data reporting of all organizations. Contrary to Alberta, we don't get the reasons why these organizations notify. We have no idea of the magnitude of the breach. We only know that X organization notified at Y time. What we do get is some meaningful statistics that they publish. We're still waiting to get a full year of comparison to see how that goes. But all in all, since the enactment of the new regime, we have 628 organizations that are known to have reported to the commissioner. What else happened? The privacy commissioner has a new logo. Very important, new logo, new website, same practices. Same practices almost. So as Kateri mentioned in her presentation, there have not been any fines or penalties related to breaches or in general issued by the privacy commissioner. That period of leniency might change. What we are noticing is a more active privacy commissioner over the last few months following the third year anniversary of the enactment of the law. What we do see is questions such as this, of course, in French. Why did it take so long to report to the commissioner? For example, 6 months after the breach. Or questions such as, what additional measures were taken to strengthen the security of accounts, networks, workstations, and servers? Or you must provide the results of the investigation or recommendations made by the external cybersecurity experts. So we see a much more active privacy commissioner asking a lot of questions. That's fine. Oftentimes we have answers to them. What should be the key takeaway for organizations is to come see counsel when reporting to the commissioner, and then if ever there's follow-up questions, to come consult with counsel to be able to provide appropriate responses and ensure there are no investigations and to keep that column of fines at 0. Moving on to Ontario. In Ontario, and the reason we're mentioning Ontario specifically, even if it's in the public sector and doesn't necessarily fit with the rest, is because there's 4 interesting decisions, 3 in the situation of ransomware cases. What happened there is that the adjudicator found that the mere encryption of personal information, so an algorithm encrypts, but doesn't necessarily mean somebody accessed it, saw it, or had eyes on glass or hands on keyboard access to it. So if an algorithm encrypts personal information, it should be considered as a use and a loss, and therefore trigger the obligations under breach reporting regime in Ontario. We also saw something interesting in a business email compromise case where the mere possibility that personal information was accessed by a bad actor, it was considered to be a disclosure and use on the balance of probabilities. This means accessing the inbox of an employee in which there is personal health information, we ought to consider that the entire inbox was compromised. Again, that's interesting and informative on how the notion of breach should be interpreted. This is consistent with another decision that came out in 2024, but was a decision that was rendered in 2020 that was being litigated and held back. In this decision, the commissioners, Ontario IPC, but also the BC Privacy Commissioner, jointly said that if an organization is unable to sufficiently verify the scope of a breach, then the scope should be broadened to include not only what was accessed, but what may have been accessed. So the key takeaway here is that we should be careful on how we determine what a breach is and the obligations that follow. So under the Ontario health privacy laws, there is no risk of harm qualifier. In other private sector laws, there might be one. What we're really curious to see here is if these interpretations are going to leak into the private sector and if other commissioners are going to follow suit in their interpretations of what a breach is. This brings us to the federal privacy commissioner, and in a case that we find particularly interesting. This is the Brinks Home decision that was published earlier on this year. For those who don't know Brinks Home, they provide alarm services to homes and businesses. And in this situation, what happened was that Brinks had misconfigured one of their systems, causing some accounts to have privileged or administrator access to information held in other accounts. All in all, this was reported to Brinks and it was eventually corrected. During that period, there were 102 accounts involved, 82 of which never logged on. So we're talking only about 28 customer accounts that could have gained unauthorized access to the information of customers. Why are we talking about this decision? It's because it's one of the few decisions that actually engages with the notion of real risk of significant harm. As we said, we had a rich body from Alberta for 14 years that did this, but Alberta only published decisions where there was a real risk of significant harm, we have very few decisions that point to the contrary, where there is no ROSH, as we say colloquially. So interesting to see how the Privacy Commission has assessed this. They started with what kind of information was there, so to determine the sensitivity of the personal information involved. So names, phone numbers, addresses of customers, emergency contact name, phone number, and whether they had a key to the house, and the alarm system model. The Privacy Commissioner found that this information is all in all considered to be sensitive. That's step one of the analysis. The second question, which is oftentimes comes into play, is what is the actual probability of misuse here? Is it just speculative? Is it conjuncture? Or is it more than that? And in this case, the Privacy Commissioner listed a series of factors, some of which are the fact that only 20 customers saw the information, that these were known individuals that were granted access accidentally, but by no will of their own or by no action of their own, that there's no unknown third parties or malicious actors involved in this case, and that the absence of any evidence of malicious activity or intent significantly reduces the probability of misuse. So this is a good framework to use when we're thinking about unauthorized access that is only accidental. For all of these reasons, the Federal Privacy Commissioner concluded that there is a low probability of misuse here, and consequentially, there is no ROSH. We welcome more decisions of this type that might be a counterweight to the body of jurisprudence from the Alberta Privacy Commission. With this in mind, I'm going to pass the mic to my colleagues Chris and Summer to further discuss on some federal developments. Thank you.
Thanks, Nareg. So I'm Chris Ferguson. I'm a partner in our privacy and cybersecurity group practice in Toronto.
And I'm Summer Lewis. I'm a technology and privacy associate at the Toronto Fasken office.
And today we'll talk about the Federal Court of Appeals decision in September of this year in Facebook versus the Privacy Commissioner of Canada. Now, PIPEDA doesn't often get considered by Federal Court of Appeal in either appeals court, particularly on the core concepts of the law. So, most of the Federal Court of Appeals decisions on interpreting those core concepts are from the mid-2000s. And when the Supreme Court considers it, it typically tends to be around topics that are sort of tangentially related, like whether PIPEDA can prevent the disclosure of personal information subject to a court order, but not really at these. So it's a fairly rare occurrence for a court to weigh in on the core issues, the core concepts of PIPEDA. And in this case, the court weighs in on what it means to obtain meaningful consent and PIPEDA's requirement to safeguard personal information. And so this is why we think it's an important case to discuss with you. And so with that, I'll turn it over to Summer, and she'll discuss the context and decisions and the relevant facts.
Thanks, Chris. So as Chris alluded to, the case we'll be reviewing today relates to a Federal Court of Appeal decision, or the FCA, we'll call it for the purpose of our presentation. And the FCA essentially overturned the federal court's decision regarding a breach of the federal private sector privacy legislation, which we'll call PIPEDA. So this decision is, in addition to the reasons that Chris mentioned, as significant as it provides further guidance on what constitutes, one, adequate safeguarding of personal information, and two, meaningful consent. So first, we'll start with an overview of the key facts to set up the context for you all, and then we'll delve into a few key takeaways related to each of the factors we mentioned: meaningful consent and adequate safeguarding. And then finally, of course, I know this is what everyone is looking forward to today, the practical tips. We'll leave you with a few ways that you can actually implement the lessons learned from this decision. So to start us off with the key facts, through its Cambridge Analytica investigation, which may sound familiar to a lot of you today, the Office of the Privacy Commissioner of Canada, which we'll call the OPC, that's the federal privacy regulator. The OPC found that a third-party application that operated on the Facebook platform, called TYDL, had collected personal information from the application's users and their friends, and subsequently sold it to Cambridge Analytica to be used for targeted political messaging. So the OPC found that Facebook failed to obtain meaningful consent and put in place adequate safeguards to protect personal information, and then applied to the federal court for a hearing. So the federal court dismissed the application and determined that the OPC had failed to provide sufficient evidence of the failure to obtain meaningful consent for the collection, use, and disclosure of personal information, and to provide adequate safeguarding of personal information. So the OPC successfully appealed this decision. We'll get into a few of the reasons why and what might be helpful to know in terms of the orders that came out of this case. The parties have 90 days from the date of the decision, so that's from September 9th, 2024, to report on whether there is an agreement on the terms of a consent remedial order. If there's no agreement, then we'll see further submissions being made on the question of remedy. So I'll pass it on to Chris to talk about some of the key takeaways from a consent perspective.
Thanks, Summer. So let's talk about how the court considered the notion of meaningful consent. First, the court found that the relevant perspective in evaluating whether an organization obtained meaningful consent is that of the objective, reasonable person. And that was in contrast to the subjective standard that the federal court seemed to apply, where the judge stated that the evaluating the consent required expert evidence and the subjective testimony of users. The Federal Court of Appeal, however, found that the reasonable person in this case is the common perspective used by objective evaluations by courts in many facets of law, and that the perspective is determined by the court and not by subjective or expert testimony. And so how did the court apply this perspective? Well, in this case, the court looked at the context of the users, stating that developing the perspective of a reasonable person benefits from the evidence of the surrounding circumstances, and that privacy and the standards of reasonable expectation of privacy is highly context dependent. And so to that end, the court looked at the demographics of the user and the nature of the personal information. It looked at the manner in which the individual interacts with the organization, including software interfaces. It considered whether there was a contract of adhesion in the case. And if there is a contract of adhesion, it suggested that there's a higher chance that there would be a divergence of an individual's expectations versus the substance of the contract, and that the individual may not turn their mind to the relationship. It also considered, as sort of Heather mentioned, the complexity and length of the contract and the privacy statement, and that where a privacy statement or contract is more complex and longer, that undermines the ability to users' ability to understand the nature, purposes, and consequences of consenting to the disclosure and uses of personal information. And finally, the court considered the nature of the default privacy settings, and it found that where a privacy setting favors more use or more disclosure, then that may be an indication there may not be meaningful consent, as it stated that meaningful consent means active and affirmative choice and not by default, and not choice by default. And as a backdrop to applying sort of the reasonable person perspective, the court also mentioned that PIPEDA balances the individual's rights to privacy against an organization's need to collect and use personal information. And it emphasizes that corporations don't have a right. And so the implication there seems is that the individual rights, at least for this court, may weigh more heavily than an organization's need. So how did the court apply this interpretive framework? Well, first, it found that the PIPEDA establishes a double reasonableness test. So that means that there are two things an organization must do. First, organizations are required to make reasonable efforts to ensure that individuals understand the purposes for which their personal information will be used. And secondly, that those purposes must be stated in a manner that a reasonable person can reasonably understand how that information will be used. But however, from the decision, the second point seems to dominate the first. And the court clarified that even if an organization made reasonable efforts to ensure that individuals understood the purposes for which the personal information will be used or disclosed, that is not necessarily sufficient. And stating that an organization cannot exercise reasonable efforts while still seeking consent in a manner that is itself unreasonable. And so from that, putting it all together, the court found that the friends of users of the TYDL app did not give meaningful consent because they were never presented with the TYDL terms, and the terms in the privacy statement were not enough to overcome disclosure that those persons would not have reasonably expected. And similarly, the court found that there was not meaningful consent for users of the TYDL app because the complexity and length of terms in the privacy statement in this case would not allow them to understand that the purposes of the disclosure here would not be what would be expected by them. And so on the point of expectations, the court mentioned that in this case, the app was requesting more information that it needed and for a purpose unrelated to the functioning of the app. So that sort of feeds into what would be a reasonable, sort of an expected use in this case. And so with that, I'll turn it over to Summer to discuss the discussion on safeguarding personal information.
Thanks, Chris. So the FCA also concluded that PEPIDA's obligation to adequately safeguard personal information can also include an obligation on digital platforms to regulate the conduct of third parties that are collecting, using, and disclosing personal information from the platform. So organizations can be perfectly compliant with PEPIDA and still suffer a data breach. However, the difference in this case is that the FCA found Facebook essentially invited millions of apps onto its third-party apps onto its platform and then failed to adequately supervise them. So in this case, Facebook required third-party apps to agree to its platform policy and also to Facebook's terms of service. And both of those imposed certain contractual duties on third-party apps. For example, they had to create a privacy policy. They had to obtain explicit consent from users for any additional purposes for the collection, use, and disclosure of their personal information. But one of the major failures here is that Facebook did not review the content of those third-party apps' privacy policies, despite having the apps have access to downloading users' data and also the data of their friends. An additional key piece of evidence that the court considered with the failure to safeguard this personal information is that Facebook had certain knowledge of, we'll call them red flags, based on TYDL's conduct. So, for example, they had actually requested from Facebook unnecessary user information for the purposes that they had stated they would be collecting, using, and disclosing that personal information. So that could essentially amount to, conduct that's a violation of Facebook's privacy policies, yet Facebook failed to investigate this. So the FCA pointed to a lack of enforcement action as a contributing factor to that finding that Facebook failed to adequately monitor and enforce the privacy practices of third-party apps operating on their platform. So to wrap up our portion of today's update, looking ahead, let's think about the practical things that you can do to implement some of the lessons learned in this decision. I'll kick this off with our lessons related to safeguarding personal information. So it's clear that contractual provisions alone are not sufficient to ensure that personal information is safeguarded. Organizations need to have monitoring and auditing capabilities and also follow through on discrepancies and breaches that are identified with appropriate consequences and enforcement action. So organizations should be reviewing third-party contracts to ensure that there are mechanisms in place that allow for monitoring and enforcement, like auditing, as I mentioned, but then also you need to take appropriate actions to actually hold those third parties accountable and ensure that those contractual commitments are actually met, and there's a plan to rectify any of those discrepancies. And then I'll pass it off to Chris to wrap us up with some of the practical tips related to consent.
So for some of the practical tips are relying on a privacy statement that is lengthy and more complex alone to obtain meaningful consent is likely not enough, especially if there are uses that are or disclosures of personal information that are unexpected for unexpected purposes. And then secondly, to sort of bolster that, then, disclosures and notices should be layered, and that deceptive practices, as those Heather presented on, would also be a factor in suggesting an organization did not properly inform an individual or did not make reasonable efforts to inform them of the purposes for the collection, use, and disclosure of their personal information. So at the end of the day, it means you want to review your interfaces and customer interactions to make sure that those disclosures are presented there, and that you want to review and simplify your privacy statement along the lines that Heather had mentioned earlier regarding the Privacy Commissioner's guide on that point. So with that, thank you very much. I'll turn it over to Soleïca and Alex now.
Thank you, Chris. In summary, I think this perfectly introduces our next topic, which is the ILO decision of 2024. So my name is Soleïca Monnier. I'm a lawyer here at Fasken at the Montreal office. My practice focuses mostly on privacy compliance program. And today I am joined by Alexander Shapiro, which is also an associate at the Montreal office. Without further ado, passing over to you, Alex.
Yes, thanks. So today we're going to be discussing the ILO decision. So basically, this is a case where the Office of the Privacy Commissioner launched an investigation to ILO, formerly known as MindGeek. And this is a company that operates various pornographic websites, including Pornhub, to evaluate its compliance with PEPIDA. So the facts are as follows. The complainant's ex-boyfriend uploaded an intimate video of her to MindGeek's website without her consent. The video was uploaded with the complainant's name, her mother's maiden name, and information about her university and sorority. This information allowed strangers to find her on Facebook and message her. Despite the complainant requesting video takedowns and even going as far as hiring a professional takedown service, the content was consistently re-uploaded anytime MindGeek removed it, and it even sometimes remained indexed afterwards. Additionally, copies or different versions of the intimate video would resurface from time to time on other websites. Additionally, MindGeek shares content uploaded to one MindGeek website with other MindGeek websites. So, for example, in the complainant's case, MindGeek stated that the content that was uploaded to Pornhub would also have been accessible on another site called Thumbzilla, which was a mirror site for Pornhub. Additionally, users were permitted to download videos directly from the Pornhub website until the function was deactivated in 2020. The complainant, what led to the complaint was, the complainant explained that her permanent loss of control over her intimate images caused her significant personal and emotional harm, which caused her to submit the complaint to the OPC, which ultimately led to the investigation. So in this investigation, the OPC evaluated the following elements. Number one, whether MindGeek obtained valid consent. So MindGeek relies on the uploader to confirm that they obtain the consent of each person depicted in the content before they upload and distribute it on MindGeek's websites. The OPC concluded that this approach did not represent reasonable efforts to ensure meaningful consent and that it should have sought a direct express consent from the complainant. Two, whether MindGeek's takedown process was accessible and easy to use. So PIPEDA requires an easily accessible and simple to use process for individuals to challenge a company's compliance and to withdraw their consent. Given MindGeek's technical and procedural shortcomings at the time of the complaint, the OPC concluded that this was not the case. Finally, the third was whether MindGeek was accountable for the personal information under its control. So PIPEDA provides that an organization is responsible for the personal information under its control. The OPC concluded that the lack of accountability in this case was demonstrated by the many deficiencies identified within MindGeek's privacy practices, including a reliance on third-party consent, on human moderators to identify non-consensual content, insufficient technical measures, and reliance on a remedial rather than preventive approach.
Thank you, Alex. So moving on to next slide, we're going to dive a bit more into the details of the reasoning of the OPC. The first takeaway is regarding consent, and I think it's the most interesting takeaway here in this decision. According to the federal law, in the presence of sensitive information, express consent is necessary. Intimate images of a sexual nature associated with the individual's name, university, and sorority allow the complainant to be found on Facebook. So here, there is really no debate on whether an express consent was required or not. Nothing was required. Here is where it gets interesting. MindGeek obtains express consent not from the individual who is depicted in the video, but from the uploader. The issue here is from whom the express consent is collected. And while the commissioner confirmed that consent may be collected via a third party in certain cases, as mentioned in paragraph 66, it is only possible where the organization has taken reasonable measures, which is called reasonable efforts in PIPEDA, to ensure that the consent is valid and meaningful. In this context, the commissioner concluded that MindGeek did not make reasonable efforts because, well, first, the information was highly sensitive. We're speaking about intimate images. And secondly, the motivations of the uploader are often not at all aligned with the interests of the individuals depicted. And here we're speaking about non-consensual intimate images. So further efforts should have been deployed by MindGeek, in the OPC's opinion. And since then, MindGeek has changed its practices and now only authorized users can upload content after identity verification. However, uploaders continue to provide consent on behalf of the individuals depicted in the videos, which the commissioner does not agree with. So in short, regarding consent, the decision confirms that obtaining direct express consent from the concerned individuals may be more appropriate where personal information is highly sensitive and where the context suggests enhanced privacy risks. So regarding the content removal process, the commissioner found that MindGeek's takedown process was not easily accessible nor simple to use. The takedown process requires at a minimum a URL, the title of the content, the uploader's username or time of upload, without which MindGeek would have been unable to locate the content. Individuals who never consented to the upload often would not know or would be unable to find all such information for the content in which they appear. And in addition, requests for removal had to be submitted on a URL by URL basis. To date, the Commissioner considers that this is not an efficient process because individuals who never directly consented to the upload to request removal of their information across MindGeek's website, they could not provide that information. So in short, appropriate consent obtention is a key element in fulfilling other obligations under PIPEDA. This decision confirms that consent remains the cornerstone of Canadian privacy legislations. And in this case, a lack of direct express consent led MindGeek to be in default of its other obligations under PIPEDA, including having a simple and easy-to-use process for challenging compliance. And lastly, regarding accountability, which is the third key point that we're outlining here, the Commissioner found that the nature of MindGeek's cumulative contraventions pointed to a broader lack of accountability in contravention of the principle that companies are responsible for the personal information under their control. Indeed, by outsourcing critical privacy responsibilities to uploaders whose interests are not necessarily aligned with the protection of privacy, MindGeek's practices created a high risk of causing serious harm to individuals whose highly sensitive personal information is shared without their knowledge or consent. So in short, organizations should consider the principle of accountability when evaluating the impact and sufficiency of their privacy practices, including consent obtention, and especially where financial or other incentives exist to adopt non-compliant approaches. Alex.
Thanks, Soleïca. So in the decision, the OPC seems to consider that the high sensitivity of the information is a determining factor in the choice of required consent, in this case, a direct express. It's an example of how consent appears to be governed by flexible contextual principles at the federal level. For example, the reasonable expectations of the individual, reasonable efforts, and individual consent. The contextual approach was also followed in the recent Facebook decision that was commented on by our colleagues Chris and Summer. In that case, the FCA determined that Facebook could not rely on TYDL app users to obtain consent on behalf of their friends because their friends were unable to review the data policies of the apps prior to disclosure. So what does this mean for you? It's common for organizations to rely on contractual warranties from their service providers that valid consent was obtained from the concerned individuals. However, these recent decisions suggest that this approach may not always be sufficient. At minimum, organizations should directly verify the consent obtention practices of their service providers, for example, recruitment agencies or background check companies, to ensure that reasonable efforts are in fact being made. Where possible, organizations should consider obtaining direct consent, or at least include a contractual right to review the intermediary's consents. Lastly, a brief point about Quebec. So the contextual approach used by the OPC contrasts with Quebec's more statutory approach, although that said, we believe the Commission d'accès à l'information in Quebec likely would have come to a similar conclusion. In Quebec, it's Section 6 of the Private Sector Act and Section 64 and 65 of the Public Sector Act that provide the framework for third-party consent obtention. These laws do not explicitly contain requirements to consider contextual elements. It's worth noting, however, that commissioners around Canada appear to be trying to align on approaches to privacy law interpretation, for example, by conducting joint investigations, joint reports, and so on. Going forward, it'll be interesting to see if the ALO and Facebook decisions will influence the way that the CAI considers third-party consent obtention according to the provisions of the Private and Public Sector Acts. And with that, we'll turn it over.
Thank you very much, Soleïca and Alex. I'm Rémi, Slama, a lawyer in the Emerging Technology Group at Fasken in Montreal, and I'm pleased to present, together with my colleague Joey, a topic that truly fascinates me: autonomous and connected vehicles and privacy. So, autonomous and connected vehicles are not just technological advancements, they are transforming how we envision mobility. While they bring exciting opportunities, they also pose critical questions, particularly regarding the protection of personal data and privacy. So we'll explore these challenges from a high-level perspective and consider their broader implications. So let's start with connected vehicles. And as you can see on the slide, these cars can communicate with their surroundings, other vehicles, infrastructure like traffic lights, and even pedestrians or the bystanders, using technology like vehicle to vehicle, or we call it also V2V, vehicle to infrastructure. Those kind of cars share real-time data on things like road conditions, traffic, potential hazard, safety. And this is supposed to make driving safer and more efficient and enable features like automatic parking, emergency assistance. And in simple terms, connected cars are constantly talking to the world around them. On the other hand, you have autonomous vehicles that can drive themselves without human intervention. And they rely on sensors, cameras, LiDARs, and AI to better understand their environment, make decisions like when to brake or steer, and also navigate the roads. Most autonomous cars today are at level 2 of automation, where they assist with some driving tasks, but still need a driver. And as for level 5, the fully autonomous cars, that's still a long way off, and it remains more an ideal than reality for now. So on the next slide, Joey, would you like to share more about some of the key challenges?
Yes, thank you, Rémi, for this introduction. Now that we've established the basics regarding the technology itself, the question of interest here is, how may this affect you? And the reality is, as you may know, that the law often engages with technological developments reactively rather than proactively. And autonomous and connected vehicle, and more generally AI, exemplify this phenomenon. Therefore, the legal framework applicable to such vehicle remains underdeveloped, which can cause uncertainty in navigating compliance. This does not mean, however, that no framework exists, and that is where existing privacy laws come into play and will apply to some data processing by those vehicles. And just to illustrate how important the issue of privacy is here, statistically speaking, studies have shown that in 1 second, one autonomous and connected vehicle can generate a data volume equivalent to that of more than 400,000 internet users per day, which is just an incredible amount of data. And among the data collected by those vehicles, just to name a few, there's telematics, road traffic, data linked to entertainment systems, biometrics, and all these categories of data may constitute personal information within the meaning of applicable privacy laws, as long as they allow a person to be identified directly or indirectly. This is particularly interesting for biometric data because biometrics by nature constitute sensitive personal information, which may, under existing laws in Quebec, have to be disclosed to the Quebec privacy regulator. And this usually commands a thorough analysis on a case-by-case basis. But what should be remembered here is that if you put in place a biometric database, or if you use biometric system or process in order to verify or confirm the identity of one or more persons, you will usually check all the boxes and will be required by law to disclose the use of biometrics to the Quebec privacy regulator. Biometrics, however, is not the only type of sensitive personal information processed by autonomous and connected vehicle. Rémi, can you tell us more about how those vehicles may enable profiling of individual and the privacy challenges posed by such processing of personal information?
Thank you, Dre. Yes, there is also profiling, of course. Connected vehicles are becoming smarter, integrating AI systems to make our lives easier. So they can handle navigation, manage calendars, and even suggest entertainment, all through voice commands. And think about a driver asking, will I need a coat later today? Or getting directions to a favorite restaurant. Here, in this particular case, this convenience comes with a trade-off and it's definitely privacy, because this system collects a lot of personal information. And in Quebec, the Private Sector Act requires companies to be transparent about technologies that involve profiling, geolocation, or identification. Users also need clear options to enable or disable these features. Profiling is a really key concern. There is also what we call geo-targeted and behavioral advertising, and it's another emerging trend in connected vehicles. And for instance, behavioral ads might use your driving patterns or entertainment choices to recommend promotions like discounts at your go-to gas station. Geo-targeted ads take it a step further because it's using real-time location data. And imagine pulling into a mall parking lot and seeing ads for sales and nearby stores. Of course, privacy laws here require also that users receive clear notifications and give explicit consent before this data is used. There is more, automated decisions, and it's very linked to profiling, because profiling can also lead to automated decisions that affect users, drivers, or even other users of the road. For example, if your vehicle detects distracted driving, it might share that data with your insurer, which will impact your premium. Privacy regulations require transparency here, especially in Quebec, and users need to know how their data is being used, the criteria for these decisions, and their rights to correct errors or request a human review. Finally, it's not really the last one, but there is sensitive personal information involved in all of this because connected vehicles are collecting increasingly sensitive data, like Joey explained, biometric or health information. And some system can monitor stress levels or detect fatigue using facial recognition, AI, and even suggesting when to take a break. Handling this level of sensitive information demands really strong safeguards, and in Quebec, processing this type of data requires explicit consent, ensuring privacy is protected and also legal standards are met. On the next slide, just want to speak about some challenges ahead, because as connected vehicles evolved, they are incorporating new technologies such as generative AI since just a few months. And those systems are capable of performing tasks like drafting a client's response or summarizing a business report, even on board. And you provide input and the AI generates a tailored response. You all know this. What makes this scenario unique in vehicles is the integration of data from various connected systems, such as your calendar, navigation history, interaction with in-car assistance. For instance, if the system recognizes frequent visits to a specific client, it might customize its suggestions based on that pattern. This blending of data, where inputs from multiple sources converge, creates a complex data ecosystem. And the challenge arises when this information or AI-generated outputs could potentially be shared with third parties, such as marketing platforms or professional services. Sensitive details, including location, routines, work habits, might inadvertently be disclosed. While it's true this risk isn't exclusive to vehicles, the real-time data collection and the vast amount of data we spoke earlier, and all the processing that occurs within connected cars amplify the concerns. In conclusion, ensuring compliance with privacy regulation for connected and autonomous systems is crucial, and this requires a thorough understanding of the technological challenges and a proactive approach to safeguarding user privacy, obviously. And thank you, everyone. I will now pass the mic to Alex and Kateri for the closing remarks sessions.
Thank you, Rémi, and thank you, Joey, and thank you all for these great presentations. It was very, very interesting. We do have some time left for some Q&A. So if we have not received any questions from the chat, I believe Alex did have questions for the panelists. So you're not totally off the hook yet. So I don't think that we have any questions from our from the group in the chat. Alex, do you have any questions for the panelists?
Yeah, I do, and I would encourage, of course, anybody in the audience to please do submit questions. We do have some time for questions, and so please submit them in the Q&A box, and we'll watch for those. I think just before questions, I just add two quick comments on one thing we didn't touch on explicitly, but is obviously a critical piece, particularly for anybody in the vital services sectors, energy, banking, transport, et cetera, telecommunications, is Bill C-26, which is cybersecurity legislation. And then, of course, any providers to that sector also may be swept up indirectly through requirements that the organizations in that sector may impose on you. That bill is currently at the Senate committee. It is, said to be a priority. We'll see how quickly it continues to move through, but it's in the final stages of the process. So watch for that. And then on a related note, in Ontario, Bill 194 was passed, which is cybersecurity and artificial intelligence legislation, targeted at the public sector in Ontario, including some specific impacts for health. Much to be determined in regulations, but wanted to make sure to highlight that. And then OSFI on the banking and insurance side, and with all the organizations they regulate. New guidance on cybersecurity has been issued, two significant pieces this year, and more to come. And as Kateri mentioned, with the AMF in Quebec, that also being a focus there. So lots of rulemaking and legislative focus on cybersecurity, I would just emphasize. And then one other comment just before we turn to questions. We do have a monthly newsletter that our group puts out, and detailed bulletins on particular topics from time to time over the course of the year, including many of the topics that we touched on today. So would really encourage you to sign up if you're not already receiving it, to subscribe for our information items. You can do that by visiting the knowledge section of our website to subscribe, or reach out, of course, to any of us, and we can have you added to the list. So with that, I'll turn to a few questions that have come in. So first for Heather, the privacy sweep and commissioner guidance, although as you noted, are not binding law, they obviously do provide a specific set of recommendations from the commissioner. Just a comment, are there some that are easier to implement than others?
Good question. I think one good place to start is by simply looking at the language that is used on websites and apps around privacy. I mean, the obvious is a privacy policy, but the same principles apply to any text that's used to talk about privacy options. One example I didn't touch on of a deceptive design pattern is like the use of emotionally charged language to persuade a user to do one thing or another. And so, for example, if someone's trying to delete an account, we don't want to hit them with repeated language that says, we're devastated to see them go, and, they'll really regret that choice. And so, all to say, I think one clear goal would be to review language that is about privacy to make sure that it's clear, that it's neutral, and that it's easy to understand. And I think if that's the case, then you've probably avoided many of the deceptive design patterns that the commissioner is concerned with. I'd also say that if you're looking to prioritize a part of the user journey to really focus on, then it's probably really helpful to take a look at moments where you're collecting personal information and obtaining consent. I think what my colleagues touched on with the Facebook decision and the ILO decision really hit home the really good points about obtaining meaningful consent. And so that's probably a phase in the user journey that's worth giving specific attention to.
Yeah, thank you. Those are great comments, and I can see that reducing many privacy policies to 3,000 words or the grade 8 level might be one of the more challenging ones for some organizations that have a lot of service offerings or more complex usages of personal information. But some really good tips there. Thank you. Maybe next up, question for Nareg. So Nareg, when you report breaches to commissioners, as you talked about, do they often lead to investigations or complaints? And sort of what's the typical experience that you see when reporting a breach to a commissioner?
It's a great question, Alex. I think the experience can vary from commissioner to commissioner, but there are some commonalities. If everything was well done and the breach was promptly reported, typically it's an acknowledgement and they'll close the file. That's a general rule. We have been noticing, at least as a trend since I started practicing, that there have been more and more questions, just to make sure that commissioners are looking at this and they're saying we're crossing the T's and dotting the I's. So you might get some questions, provide responses, and typically commissioners have been satisfied. Now, sometimes we'll receive complaints. So a commissioner will reach out to us after reporting a breach saying that they received a complaint from an individual who received a notice. And most of the time, this has to do with, why do you have my information? Or rather, often, why do you still have my information? So individuals that do not think they have a link with the organization or ought not to have a link with the organization will raise a flag with the privacy commissioner. And it has less to do with, oh, you had a breach. What were your security measures? Did you safeguard my information appropriately? So something to watch out for in terms of data retention practices. And then investigations, to the question, I guess, is they're quite rare. There needs to be some sort of public policy reasoning, or a large number of individuals that are involved, media spotlight, et cetera, that will trigger a full-blown investigation by a commissioner. And oftentimes they're pan-Canadian breaches, and many commissioners will team up together to investigate, just because of the resource-intensive nature of a proper investigation. That's been my experience.
Wonderful, thanks. Another question in for Julie and Sam regarding artificial intelligence. So question, what are some of the ways that AI usage and privacy laws intersect?
Yes, Alex. Actually, if the AI system enters personal information, which I assume it will be the case in the most situation, both AI Acts and privacy laws will apply. I'm going to give an example and some can jump in. For example, under the GDPR is technological neutral. It means that it applies whatever the technology used. For example, under the GDPR, biometric information is sensitive information subject to specific requirements, such as carrying out a data protection impact assessment. Under the EU AI Act, biometric is a high-risk system subject to specific requirements, such as assessment and documentation requirements. So in this context, company will have to comply with both legislation regarding AI and regarding privacy.
Sam, did you want to add anything to that?
No, Julie covered it pretty well. I mean, obviously, as personal information is being used at any point, I would say just, automated decision making or decisions about users in any way, or prompts really to make users act in a certain way. I think that's being scrutinized quite a lot and really considered under privacy laws as well.
Thank you. There was another question just for the link to the AMF rule, which will be provided to you as well. And also we'll be putting out a bulletin from Fasken as well. So watch for an upcoming bulletin on the AMF piece. So with that, we've wrapped questions. So Kateri, maybe back over to you to either close us out or if you had any final questions to ask.
No, it's okay. Thank you, Alex. I just wanted to let everyone know that we did get a question on whether we could provide a link to the AMF rules. So I posted in the chat one link to general information and another link to the French version of the full rules. We have not at this point found the information on the website from the AMF is not available in English. We should be able to locate, however, an English version of the rules, and we can post that later on the webinar if it's available. Otherwise, we'll find a way to get it to everybody. So it's been a great session. Thank you so much for your time today. Thank you, everyone, for joining us in such a large number. Thank you to our panelists and colleagues. You guys did a great job. There's a link for the Ontario and Quebec Law Society certificates that is on your screen and also available in the chat if you want to register the credits. And for our BC viewers, I understand that the Law Society of BC title has also been added to the chat as well. Again, thank you for coming and have a great afternoon.